Hello, everyone. I'm Michele Shuster with McMurray and Schuster, and I have the very distinct honor of having Otto Foerster on our webinar today. He and I have been talking about doing this for a while, and we finally were able to pull it off, Otto, where both of our schedules worked out, and we had something interesting to talk about. So thank you so much for being on the webinar today. You want to go ahead and introduce yourself?
Yeah, thank you so much for the introduction, Michele. My name is Otto Foerster. I'm an insurance broker down in Miami, Florida. It's summertime. Stanley Cup finals are going. I don't know how many Canadians we have, but I'm a big Florida Panther fan, and so
Go Panthers.
we're excited here. But it's summer. Um, we're here to educate and just help people understand a little bit more about what is going on in the insurance marketplace and how buyers can become better, more educated buyers. And Michele is got a great a presentation here that we'll go through together. I've known Michele for
Long
too
time.
long, and it's a really great community that we have in the lead gen telemarketing world. And again, I consider Michele a beacon of the space, and so it's an honor to be on today's webinar with you and your team. So thank you for the invitation.
Yeah, very kind words. And I love, love, love this title that you came up with, Otto, for so many different reasons. But mostly it's the reason that I was motivated to try to get you on for a webinar. And that's because you don't want to ever be caught asking that question wait, I'm covered for that, right? And that's not a question you want to ask when you need that type of coverage. It's something you really need to give forethought to, and make sure you're working with the right kind of professionals for your insurance coverage, because this is really a tricky area. And I think that most insurance professionals that I talk to don't understand TCPA. They have a little bit of an understanding of the privacy laws just because they've been so much in the forefront and affect everybody. But that, along with the D&O insurance, the directors and officers insurance in this area, is something that they're just really not familiar with. So we're very lucky to have you here today to really make sure that none of our clients or anyone on this webinar is ever asking that question of, I'm covered, right? So with that, I want to just give the disclaimer that while I am an attorney and we may be talking about legal issues today, it'd be mostly insurance, but maybe some legal issues. We're not providing legal advice, and please feel free to reach out to us if you do need that. So let's go ahead and let's get started here. And so, it's interesting. I remember a case from a while ago that was talking about TCPA insurance coverage. And this was back in the day that we remember well. That seems like a long and far away time now. But it was when, before the Facebook versus Duguid case, which clarified the definition of an automatic telephone dialing system under the Telephone Consumer Protection Act. And with that decision, we went from basically any type of phone that could dial a telephone number being an automatic telephone dialing system to a very specific type of system that would randomly and sequentially generate telephone numbers and then either store or dial those. But back in those days pre that case, there was a court that came out and they were looking at insurance coverage, and it was for damages, I believe. But they were talking about how the damages in the TCPA can be looked at as penal, and they excluded the coverage for that reason. So there's lots of different ways I think that you can exclude TCPA coverage in contracts or in insurance contracts. And so I'd love to, just get an overview of what we're looking at here when we're talking about insurance coverage in this area.
Yeah, so let's first just start. Why do we buy insurance? And there's really two principles of why somebody's in the transaction window to purchase an insurance policy or agreement or contract from a risk-bearing insurance company. Those companies or insurance carriers are in the business of taking risk. That's their enterprise that they do every day. And a consumer of insurance has risk on their balance sheet, and they're trying to contractually obligate an insurance company to relieve them of that balance sheet risk, that liability. That could be claims paying ability, defense costs, fines and penalties, like some of the things you were talking about. And that's what the basics of this is. And why do you buy insurance? You buy it because you're unable or unwilling to sustain those risks in your business, or the insurance company or the insurance marketplace is providing a price that's so low that it just doesn't make fiscal sense to let that liability sit in your balance sheet, and we can punt that to the risk-bearing insurance market. I think a lot of brokers in my situation are more apt to just take what's existing, bolt on one or two things, and then just resell the same kind of renewal process year after year after year. Our mentality, and I think any smart broker, an intelligent broker, really sits shotgun with the business owner or the management team of the business and ask the questions: what are the biggest risks in your business, and how can we mitigate those risks? And is it smart or financially intelligent use of capital to mitigate those risks with insurance? And so, that's a sophisticated way of looking at it, but I think it's important, instead of just having the insurance bill's here, we need to make a payment, we need to sign some papers. I think most folks on this call and that are running, these types of businesses aren't in that world, but that does happen, and it's an important part of the discussion and the relationship with the broker. Again, the second kind of 2A of that, do two reasons why people buy insurance. The other is because you're contractually mandated, and that's really what a lot of folks that I talk to every day are required to buy certain limits, whether that's a cyber limit or an E&O TCPA limit. Rare is the day we see a D&O requirement in a contract, unless it's from a private equity partner. But those are the three types of coverages we're going to be discussing today. And yeah, I'll just take the slides here.
Yeah, I don't know if I can just like
Michelle.
emphasize
Sure.
something on that last slide you had.
Yeah.
And it's definitely critical for what we're talking about, insurance coverage, because a contract requires it. Your service agreements may require it, but this is an issue that we're seeing a lot of lately, that companies are not having sufficient contract management systems in place for things like insurance requirements that automatically put you in breach of that contract, which can have some pretty significant ramifications. But also with the new state privacy laws, there are requirements that you have to specify in contracts, especially if you're a data controller or working with data controllers. And so this is just a good reminder as we're starting off this webinar talking about, well, you want to especially look at this because of contracts. There's lots of good reasons, and really critical to have that type of contract management platform in place.
Great point, Michelle. So yeah, we'll hit some of the, originally kind of the history of insurance. It was just general liability coverage. Everybody's kind of familiar with that term of art. There's two parts to a commercial general liability policy. The acronym for that is CGL. There's bodily injury and property damage, which in this space, and you're in the telemarketing lead gen space, very 0.01% are you going to be found legally liable for causing bodily injury or property damage. But it's really would have been found in that personal advertising injury portion of the policy. And this is insurance is an agreement or a contract, and there's a standard form which is built out by ISO, which is the Insurance Service Organization, and then there are forms to that boilerplate policy. They get changed over time, and this is a timeline of how those forms have changed. So in pre 2004, there was no exclusion for TCPA or privacy in a boilerplate general liability policy. Then in 2005, right around the time when a lot of folks were sending a lot of faxes, emails, phone calls, there was an exclusion that became available via an endorsement. And then in 2007, it was actually fully excluded from the general liability policy boilerplate language. So and then there's some additional line items here showing some privacy and personal confidential information exclusion. So it does get a little in the weeds, but it's important to note that this is the arc of how insurance works when something pops up or bubbles up in the world that becomes risky. This is an example of how the insurance industry is going to address that over time. A good kind of eureka example would be pre-COVID, post-COVID.
Mhm.
Pre-COVID, people were pretty loose about a pandemic exclusion or a viral exclusion in the policy. Immediately, you saw it built into the policies overnight. If there was some gray area, some carriers are pretty stingent about that. But this is to juxtapose a COVID or a pandemic exclusion to what happened to privacy and TCPA over time. That was immediate. This is over a 3 year period, 5 year period where things start to get watered down. So, it's just important to note that if you're buying a general liability policy today, there's going to be an exclusion for the privacy and TCPA in that policy. So the days of being able to say, "Hey, we have that. We already buy insurance." If you're only buying general liability, you really got to take a look at that policy. And this is an example of how things will get taken out or reduced down over time.
Yeah, it's interesting, this timeline, and it's probably just a good reminder for things even beyond what we're talking about here, which is getting coverage for or getting a rider for TCPA, privacy, those types of things. If you look back at 2004, that's when the do not call laws took effect. And then in 2005, we saw the states passing those as well. And then as you pointed out, the fax laws came in through the TCPA, and then we just saw a huge increase in TCPA lawsuits from then on out. And so it's a good reminder that as you become more aware of these types of potential liabilities for your company, it's a great time to call Otto or your insurance broker and have these types of conversations, especially at renewal time.
Yeah, Michelle, there's some slides in here that get pretty into the weeds. These are some sample exclusions. I'm not picking on anybody here. These are all great partners. But these are just some exclusions where the and mostly I'm not asking people to read this. I'm really trying to pinpoint how difficult it is to read.
Yeah.
And a business owner or somebody in management looking at this, their head's going to start spinning. So it really is just incumbent upon them to really build a personal relationship with their broker, somebody they trust that can help demystify this buying process for them. There's can spam exclusions, TCPA exclusions, there's federal, state, and local exclusions for any kind of acts arising from those. Again, this all stems from maybe an FCRA, which is a credit, and so those are folks calling on debt. So it's a little intermingled. But this is how these policies are written, and you might think you're paying a lot of money for something that you don't know there's an exclusion for. So it and I think going back to that original slide, it once you buy it and you think it's in there, it could get taken out over time. We have a slide here of showing an example where during a renewal, and I might be messing up my uh, timing here. Here we go. Yeah, these are just all examples of these exclusions. Here's an example of the endorsement change where there was no exclusion in a policy. Uh, Sign and drive, move forward. The renewal comes in, and this is what you might receive in the mail. This is a great example of, hey, these are all these revisions to your policy that are standard, and there's really nothing to worry about. And next thing you know, they've excluded some coverage that you care deeply about. I'm not picking on any particular carrier, and that's just how the industry is. I personally don't believe the carriers are trying to be sharky or difficult to deal with. They're trying to get one past you. The overwhelming majority of the reason why they have to do this is because the state and insurance regulation requires timing and 120 days, 90 days, advance notice. And so a lot of this is for a regulatory standpoint. but it does water down policy language, and it's something
Mhm.
that's important to review with your agent or with your broker on an annual basis, because this is a great example of how you might have bought something 2 or 3 years ago, and then it was taken out or removed over time. They notified you via mail. You think it was there and it's not. So that's why it's important to just give these things an annual review. What it's just something that is part of being a business owner who's vigilant about their liabilities and exposures.
Yeah, it's interesting. I don't get a lot of clients that ask us to review their insurance policies, but it's probably a good idea, not only to work with your broker, but to make sure that your attorneys that you work with regularly, especially in the compliance space, to review your insurance contracts, just to make sure that if you're going to need coverage in the future, it's in there, or if it's not, that you're working with them to figure out a way to get something that would give you at least some form of coverage. It'll be interesting to hear you talk about the types of coverages that you're seeing out there now.
Yeah, so we've been talking a little bit about the different opportunities for coverage to reduce businesses. Cyber's become um, a huge coverage that folks who are playing with data, who are talking to folks about aggregating personal identifiable information. These become big liabilities for businesses where they're warehousing this, and frankly, a lot of folks might have the attitude of, "Oh, that's in the cloud. I don't have to worry about that." Well, I have a personal opinion on that. Read the agreement with the cloud provider, and they're going to say they have no liability if their cloud goes down. And it's important to understand that when you have a digital business in a digital world, you might be operating from your home or from a place of business, but you are touching 50 states in many ways, and these states will have individual laws for the data that you're warehousing, and that is just a risk that is very difficult to manage if you're a medium-sized business. And going back to the conversation we were having in the opening here, this is a very inexpensive policy to purchase relative to the coverage that you can use for your business. So it's not expensive. Nothing here that we're discussing today is expensive on a relative basis. Actually, my personal opinion is it's too cheap. The market could increase the price, and folks would still buy. I really believe that.
Yeah.
Um, Let's see here. This is again we initially spoke about the general liability kind of sample exclusions. There's some exclusions here for some cyber coverages that could be considered important, specifically on TCPA. Again, not picking on these carriers; these are great partners. These are just examples of forms that exist in the world. Um, Again, you're going to see here the term of art is going to be unsolicited communication. Um, they could call it a TCPA endorsement or uh, let's see here. This one is unsolicited materials exclusion. So it's not always the same. It comes in different. Here, the Hiscox option is unsolicited telemarketing. So every carrier is going to call it something different. Um, and then you've got some additional exclusions like regulatory acts, criminal fraud acts, data collection exclusions. These are just things that when you're in a digital business, trading could be leads, could be data, could be making phone calls. You are exposed to state and federal laws that can hurt cash flows when you have to start paying for attorney's fees. It can create a lot of headache because you're not managing your business. You're now managing some lawsuits. You've got to bring in attorneys. You got to bring in a team, and it can ruin the business if it really becomes catastrophic. Again, I'm not particularly going to discuss nuisance, what I will call a nuisance claim. A Tom, Dick, or Harry that sent a note that says, "Hey, I got this phone call or I received this text message and and I'd like to get, a handout for $1,500. Those are not, you know, large issues. Those can be handled, on a one-to-one basis, and contact your attorney or your counsel to deal with those situations. The insurance marketplace is there to handle the large class action lawsuits, the lawsuits where you've got multiple issues, and they aggregate and compound. A great example would be you you have one vendor that you put 80% of your kind of lead or your traffic with, and they have a rogue affiliate, or they have a rogue issue with. It could be a mistake. It may not be malicious in nature. It just might be just, hey, we made an honest mistake. And because 80% of your business comes from that one vendor, that one marketing partner, you become exposed. And it wasn't because you're running a poorly run business, or that you don't have the right compliance in place. It's just that is a function of the business that
Yeah.
we're in. And Michelle, I'd love some comment there, if you had.
Yeah, yeah, yeah. And it's interesting. I think a lot of times that companies will think because they're not the ones that are actually physically dialing telephone calls or collecting the leads, that they're not really don't really have much to worry about with liability. But really, the extent of liability that's included in these, especially the telemarketing laws, but now privacy laws as well, it extends to sellers through a vicarious liability theory. And so if you're hiring a telemarketing company, if you're working with lead generators that could be placing lead calls for you, then all of that can roll uphill. And so critical that you make sure that you've got insurance for that type of thing. And also, I can't overemphasize the point that you just made about the distraction that these types of lawsuits are. And it's the distraction of, working with your attorneys, as wonderful as they are, throughout the litigation phase of this. Discovery is very difficult. Having negotiations, worrying about attorney's fees. Unfortunately, that's reality of what happens when you get involved in a lawsuit. All of those types of things are a massive distraction from the business. So being able to take care of some of those worries through working with somebody to get insurance that's in some way going to cover it is really important. One of the things that's near and dear to my heart, Otto, is, let's say that my clients, so they come to you and they are able to get an insurance policy. Frequently, these insurance policies will require that you use a panel attorney for your legal counsel in these cases. Tell me how that type of thing, usually plays out, and
Sure.
whether clients have the ability to maybe designate or work in specific policies about being able to use their own attorneys.
Yeah, it's a great question. Number one, the insurance companies use what's called or counsel panel, and those are pre-designated attorneys on a regional basis based on jurisdiction. Again, back to that digital world, you might be a business that's, in Delaware or Wyoming. You're in your house or condo in Puerto Rico, and you get a lawsuit from Pennsylvania. So there's a couple jurisdictional situations that work there. Uh, you know, we might need an attorney who's licensed to practice law in Pennsylvania to handle that case. So that will drive an initial part of the panel counsel assignment. They'll have a panel rate on an hourly basis that could be $150 an hour. It could be $200 an hour. Every carrier has their own different thing, but it's definitely a subsidized rate. That's part of the aggregation, or the reason why insurance companies can maybe offer some things that a business can't, because they can get access to a little bit more of volume, and from an hourly standpoint. So they're going to pay a reduced rate, and then they're going to sign panel counsel to adjust and defend the case. When a client or an insured has an opinion on who they want to use, they can pre-negotiate a choice of counsel endorsement. That does exist. Typically a client will have to have a significant amount of spend to negotiate that with an insurance company. So if you're paying, a nominal amount, carrier's going to kind of laugh you out of the room because they don't need you. That they are going to run their business. They want to run their business. But over time, if you have a relationship with a carrier and you spend significant sums with them over a certain period of time, you might be able to negotiate a particular firm to represent you in these cases. I have seen that. And the other solution that I can provide somebody like Michele or other attorneys that are asking insurance company dollars to pay their fees is if there's I have seen in the past and personally taken care of where the carrier will take their rate, let's say to use an even number, $200 an hour. Um, they'll pay that to the attorney firm who's not on counsel, as long as they prove that they have the chops to handle the case. And then the client will pay the delta on whatever the agreed rate or agreed hourly fee is. And so it becomes more of a co-insurance provision, really, or a co-insurance kind of situation where the carrier's paying a portion, maybe half or two-thirds of the fee. I have seen that clients are happy with that. They die in the wool with their attorneys, as you know. Just like some brokers, that this is a personal relationship world where people care deeply about who they work with, and they just know they're familiar, they're comfortable, and so they're willing to pay additional. And again, that helps. And when you look at a case that could take 6, 8 months to get worked out. There could be a judgment at the end of the rainbow. It adds up and it becomes even if the client is paying, let's say, a 50% of that fee or 60% of that fee, they're still ahead from a capital outlay standpoint.
Yeah, yeah. What types of caps do you usually see on these policies, Otto, including legal fees and damages and those types of things? What's kind of a routine amount
Yeah,
for
so
limits?
most folks, $1 million limit is still, the a standard,
Mm,
that's where a lot of folks start. And then we'll see sublimits anywhere from 50,000 for a TCPA
mm,
situation all the way up to full limit. And,
mm,
there are folks that buy 10, 15, $20 million worth of limit in the market. A lot of that's either driven by some contracts that they've signed with some large partners, and they're contractually obligated to carry that limit. They otherwise may not carry that limit, may not be uh, fiscally responsible for them to do that just because of the risk profile of the business, but because they have a contractual agreement, they buy a significant limit. You see that from large healthcare insurance companies. You see that from some big partners. And typically, my opinion of that is not because they think that risk exists. I think it's kind of one of those, let's weed out the bidders on this situation. So, if you can qualify by getting that large limit amount, then yeah, you belong in the room. If you can't get 15 or 20 mil of limit, then no, we don't want to talk to you. So it's a way to weed
mm,
out some of the folks that just can't get there from an insurance standpoint. So I don't necessarily believe that risk is commensurate with limit in some cases, but
mm.
every case is unique and different. So now
Yeah.
we've got back to the slides here. We've got some solutions.
Let me just ask you a question real quick, Otto, before you get into those, because it kind of flows into that as well. So when a new client comes in or potential client comes in to talk to you, what does it look like as you're kind of setting up that relationship, and what should they expect, and what kind of information do they really need to bring with them?
It's a great question. We live in a world where everybody loves email and they want to just,
You mean they don't come to your office anymore, Otto?
which I'm fine with, but I'll go anywhere. But if
Mm,
they want to talk via email, that's fine. But typically, my personal style is, I'll try to have a 5 or 7 or 10 minute conversation with somebody
mm,
just to educate them a little bit, answer some of their questions, and I can typically give a pretty solid indication based on what their revenues are. Revenue is a big
mm,
determiner of premium in this
mm,
space. Um, what kind of claim activity they've had over a 3 or 5 year period, and what I believe the market is looking at for an account that looks like and smells like just like them. So,
mm,
um, I think it's important that, and I say this a lot, and if folks know me, they probably heard me say that before, but we don't share client names with people, and confidentiality is super important for us. We can ink that in agreement, or we can shake hands on it. It's the same to me. Um, but so we won't say, "Oh, I've got XYZ account. I'll just pull them up." We might describe, "Hey, you told us that you're making, 20 million a year doing leads and making some text messages and outbound phone calls. We'll look in our accounts and look to try to find an account that's similar." And that's something that we use to create a comp based on that 5 or 7 minute phone call. It's difficult to do that via email
Mm,
because they might not understand what you're asking, or so I really, my personal opinion is you can reduce a huge chatter of email back and forth with a 5 or 7 minute phone call right off the bat. But some folks just still want to do email, um, and that's fine. But after you get through that, Michelle, really you have to get an application together, and
mm.
folks that are familiar with the buying process, those apps can be onerous and they're difficult to get worked out. But you got to get through that, complete the application. Sometimes there's some financial requirements, and then a broker will go send that to market. And that's where the broker's hat gets turned on, where they're really good, or they really don't have the relationships that they might say. And that's where really the rubber meets the road. So a good broker will be able to put something together in a couple days with a complete submission and get pricing, terms and conditions.
Yeah.
On a complete package, whether that's E&O, TCPA, or that's cyber, D&O. We'll talk a little bit more about how important D&O is in this space and overall. Um, but uh, but yeah, it is a application, what we call sup apps or supplemental applications. Those are gold. Those are gold for brokers. Like we die for those, and getting them completed is a big part of my team of 5 or 6 folks. They spend a lot of time just sending follow-ups on those supplemental applications. They're bare, but it is currency in this business, and you got to have it.
Yeah, and I think that's probably what you do so well. And it's why when people ask, can I get TCPA insurance? That's what they'll call it, right? We know that's not
Yeah,
actually what it is, but they'll say TCPA insurance. I don't correct them, and I just say, no, it is possible. You do really have to evaluate what it is that you're getting. But yeah, it is absolutely possible. And then I usually send them over to you to have those exact types of conversations. And so I think that is something that you are particularly good at, finding that type of coverage for customers in the spaces that I deal in mostly. So have always appreciated that.
Yeah, it's important. I can't remember what slide it's on, but I'm gonna bring it up now because I really think it's
Yeah.
important. The other thing that I spend a lot of time with is curating what's called a professional services definition for folks, and that's something that I think is underappreciated for many people, and it's a low-hanging fruit for any risk manager or CFO, whoever's managing the insurance, is to pull up your policy, and it's going to be right there on the first or second page. It's going to say professional services definition.
Mm,
And the question that I would pose to the group is, does this describe what we do as a business? If
mm.
it doesn't, you do not have insurance. What one of my old mentors would say, you're chief running bear with no coverage. Woo. It's but yeah, it's not good, and it's something that, if your business has changed over time and you've not updated your definition of professional services, you have no insurance. The entire contract of the professional liability agreement stems from wrongful acts arising from the performance of professional services.
Mm,
So if
interesting.
the claim does not arise from the performance of professional services, the coverage does not trigger. So if you sell leads and it doesn't say lead generation or lead sales in there, you have no insurance. You
Mm.
might have spent 100 grand for insurance that will not pay to indemnify and defend you in a lawsuit stemming from your performance of lead generation for others.
What a critical takeaway.
It's super important, and and it's again, it's not a secret. But if you're dealing with a professional in that niche or in any niche, you can be a dynamite manufacturer for all I care. It really just got to make sure it says dynamite manufacturing on the definition of professional services. But it is important, and it's something that I personally think is well, it's critical. I mean, it's really can't really over explanate that or over uh
Explain.
there you go. It's just critical.
I'm here for you.
Thank you.
Yeah.
Um,
So I think we're probably on the directors and officers liability
yeah,
at this
super
point. I think it's a
important here.
great,
So,
yeah.
so yeah, this is something that I think is also misunderstood for many folks. You might look at it, we all call it a D&O policy. So most folks who own private businesses are like, yeah, we don't need that because we're not public. We don't have a big board, and we're not really, we don't have exposure for that. But there are multiple buckets of insurance inside a D&O policy that can help the management, the officers of the business, the directors of the business, and the actual entity itself. There is corporate entity protection inside the D&O as well. So you know, it's just a terrible label to describe what it actually is. You think you're buying insurance for people, but there is provisions in the policy for the business. So there's another carrier out there that actually is actively trying to change the name of the policy. They want to call it a different name because it just doesn't, business and management policy.
Mm.
It's probably a better name, but it really is important to understand that there's corporate entity protection inside the D&O. And then there's something that we'll spend some time talking about, which is the A side. That's that green box there. And I'm going to need some help from Michele to talk a little bit more about the personal liability that folks
Mm.
undertake when they're making some outbound phone calls or subject to the federal laws that regulate this world. Um, Side A is that personal liability for the owners and directors of the business, and where we have found some significant value, and this is from a premium standpoint, is something called Side A DIC. Well, alphabet soup. I'm sorry, but that's just what we call it. DIC is an acronym for difference in conditions. And you can see on this slide here, there's the green box, and then there's to the left of that green box, there's a small sliver of orange. That sliver of orange is illustrative of a drop-down provision where that additional side A coverage that you're purchasing, minimum premium could be 5 grand, might even be less than that. For $1 million, you can get where they'll drop down to be first dollar with no deductible for any kind of lawsuit stemming from these situations. We have an example. I think it's on the next page here of um,
Mm.
where a little bit more illustrative. And actually, when I was doing some research for the webinar from one of our carrier partners, they actually put in the marketing slick from the side A difference in conditions policy, they put in a TCPA claims triggers the DIC. There's an example where the carrier is going out and saying, "This is the claim we've paid." And I was like, "Michele, look at this." And she's like, "Oh man, you're such a nerd." She says. But but yeah, it really is funny where I have not seen, and it's relatively new to my world in the past 2 or 3 years, where I've really been talking about side A DIC as an important a part of the overall, you might call it an insurance portfolio, or but it becomes such a and it's so cheap. It really is inexpensive, and it's something that I really recommend looking at. It is required. You do have to have a D&O policy to buy a Side A policy, Side A difference in conditions policy. But if you are concerned about that personal liability that Michele is going to spell out for you in about 2 minutes, you can mitigate that very easily. Can you help describe some of that personal liability that somebody might
Oh,
take
you're teeing
on?
me up
Yeah,
there, Otto. I
sorry.
thought we were getting to that. No, that was you
Sorry.
teeing me up. I
Okay.
swear I'm paying attention.
Okay.
No, I mean, it's really critical because when you look at the actual language in the TCPA, it provides that there is, as I was talking about before, liability for those that are directly making those telephone calls. But then there's this additional provision for those that are so involved in the making of those telephone calls. And specifically, that's owners, that's directors, that's officers, that's even managers. If you think about managers of call centers or managers or employees within the company that are involved in the type of activities that are going to trigger a violation of the TCPA, all of those have specific liability in the TCPA. So really important that, I guess one is employee, you should be asking your employers about this, but also that as a company in this space that you really understand how broad that liability can be. And so we're not just talking about the company that needs that coverage for a TCPA or a privacy claim or something of that nature, but it really does need to go beyond the directors and officers. And it's kind of an unfortunate thing that we have seen lately. There are plaintiffs' attorneys out there that are naming owners of companies, managers within companies, and they're doing it because it really, and intentionally they're doing it because it really turns up the screws on that case. And I think in their eyes, they see it as a way to get the company to really be moving towards negotiating a much higher settlement and trying to get out of the case quickly to eliminate that type of potential liability. And it's not unusual to hear plaintiffs' attorneys now asking for, a summary of assets of owners within companies as they're talking about the type of damages that they are expecting. They're not basing it on what the actual violations are, but what they can get in a settlement or what they think that they can get through a judgment. And so really can't overemphasize enough here how important it is to really take this umbrella approach when you're looking at insurance and making sure that the acts themselves are covered, but then all of those kind of collateral things like, directors and officers and attorneys' fees and all of those types of things.
Yeah, one of the examples you'll find is maybe a regulator will freeze the assets of the business and you
Mm,
can't defend yourself. So an
it's a
insurance
great point,
company being
Otto.
able to use their dollars to defend you is a huge win. When again, we're not saying you did anything wrong, but you always have to defend yourself, and you need, fresh powder to do that, and insurance is a place where you can get that worked out. It's just a way to diversify the business. It's also important to note that these DIC policies are, you might think of them, really, I do think of them as that old school umbrella for that personal owner of the business, because it
Yeah.
basically just says if there's no other coverage anywhere, we're going to pay. And as long as you're not a complete fraud. And um, and the carrier actually even goes out and said, well, not any individual carrier, but it even says, comma, we'll cover you up into the point where the court or a judge or a settlement says you're a fraud. So you even get a little bit more uh, time before the carrier shuts off the spigot of money. So it's just great value. If these policies cost hundreds of thousands of dollars, I might say, yeah, it's may not be a good allocation of capital, but they're inexpensive, and they're not difficult to find, but they are bespoke. They are not something that a typical, John Doe insurance agent broker is going to wake up and say, I'm an expert in this, and they're going to fumble around looking for it. Once they find it, it looks like insurance. You can get it worked out. If your brother-in-law's, kind of a little bit of in the dark, they can get up to speed pretty quick. Um, but it is something that most brokers are not used to having these conversations. It's technical. The underwriting can get in the weeds, and second nature to other brokers in the business who really understand the risk and understand the value proposition that something like this provides to a business, and willing to do the extra work and willing to put in the extra effort to explain it to a management team. Really think it's It's
Yeah.
underpriced, and I probably
I-
shouldn't say that, but insurance companies are raising their prices as I'm talking, but yeah, it really but it there's just so much value there. So we'll go to the next slide here. So yeah, kind of looking at cyber liability, and Michele was really pressing me to discuss, and I think it's important to discuss some of the privacy uh, laws that are changing daily, weekly in the world. Um, if you really want to understand how a cyber liability policy is going to protect you in those situations, you're really going to have to look at the definition of what a breach is, how a breach will affect a business. Um, this I brought this one up, and I hate to read it. I'm not going to read the whole thing, but there's a provision, I think it's E here, failure to implement, maintain, or comply with privacy policies and procedures. Um, so
Mhm.
that doesn't sound like a breach, but they are defining that as a breach. So if you just were neglect and forgot or did not maintain, they're this particular carrier is calling that a breach, and that would trigger in a case. So I think that
Are
there are
these
other carriers that are
exclusions or
going to
is this
exclude that.
triggering coverage, Otto?
Yeah, yeah. Again, every carrier is going to write it differently. It's just an example of you might say, oh, well, this isn't a breach. But what I think the teaching point here is every carrier is going to define in their language a breach to be different things.
Hmm.
And that's why no carriers or no policies created equal. And if you're really looking to batten down the hatches on the business, you know, you might have to break these things out. You might have to look at them, because a breach in this case is not just a breach. There's other items in here where they're bringing up privacy regulations. They're bringing up just neglect, failure to implement the most current things, and that doesn't sound like a breach, but it is from a definition of a
Right.
policy. So
Mhm.
um, let's see here. Uh, So yeah, this is kind of getting a little bit more into how carriers and insurance companies define. Uh, we went over what a breach might be, how that might be defined. This is definition of a claim. Um, where we're kind of showing where damages for taxes, fines, penalties might be excluded. There are other definitions where they'll pick up fines and penalties. Um, some of this might be critical to may not be critical to if you're already buying insurance, it could break a tie. You might say, oh, if price is the same from carrier A to carrier B, and carrier A is giving me fines and penalties, and the other carrier isn't, well, we're going to go with carrier A. If and that's where a broker really shows their stripes is being able to create a market in your risk, and get two carriers to compete on the business. And one way to do it is to compete on price, and another way to do it is to compete on terms and conditions, which is the language, the way the policy is written. And that's something that, it's hard to put on a spreadsheet, and it's hard when you're presenting to a management team and say, hey, our price is up 20%. How do you put a value on what fines and penalties ultimately could be to a business over time? You can't, it's difficult. So maybe a management team might say, well, we're not going to pay more for that. But give give the option to management. If you're in that C-suite, give that option to the board that you're presenting these things to. Um, the market can provide them, and push for those.
Just as we're getting to the last 10 minutes here of the webinar, I'd encourage anybody that has any questions for either Otto or for me, I'm happy to answer questions as well, to go ahead and put that question in the Q&A box that's included with the webinar. And I should also let you know that this is being recorded, and that we will be making this recording available on our website here in a couple of days after the webinar. So
Some
feel
of
free to
the
ask questions.
some of the things we also hear a lot, Michele, is, oh, I have insurance for that.
Yeah.
And uh, and it could, you might have it. Here's an example of where they'll have 100,000 in coverage, but it's defense only. Um,
Mm,
there's no there's no indemnity payment. So if you are found legally liable for the judge dropping the gavel, or a settlement case, the carrier's not going to pay that judgment. They're just going to pay the defense costs. So, and maybe a client wants that. And no one's saying, if as long as the client or the insured knows what they're buying, that's great. But I've personally dealt with situations where when I explained what that was to an insured, they're like, "Oh, I didn't know it was that.
yeah.
I thought it was for everything." No, no, it's defense only coverage. So we had to change them out, and which we were successful in doing. Um, here's some examples of where it's picked up. 50,000 sublimit for TCPA. Here's an example of a 250,000 defense only sublimit. This was inside a D&O policy, by the way. Um, so there are lots of different ways uh, to purchase the coverage, that's important for the business, and you know there's just many ways to do it, and as long as you know what you're buying, you're fine. Michelle, I'm not seeing anything come up in my chat here. I don't know if I'm doing this right, but
I don't know if I am either. I'll pull up the questions here in a second, but just really important these takeaways from what we've been talking about today. And if nothing else, I hope this week you go back and review your insurance contracts. Make sure you have the coverage you think you have. If you don't have coverage, do they need to wait until their policies renew, Otto, or is this something that they can reach out to you now to have a conversation?
yeah, there's always a conversation to be had. Sometimes you can look at it where they're maybe further enough along in their policy period to justify midterm change, and it won't hurt them from a cash flow standpoint. Other times it could be important to wait. It just depends. But just looking at doing a review, looking at things like the definition of professional services, looking at the endorsements, looking at how the policy's written, um, and using your broker, pushing your broker to get you, the best terms that are available in the market is uh is important. I would say you can always push. We get a lot of folks that push us very hard to it's your money at the end of the day. It's not our money. We're trying to get best execution on the transaction. Um, but uh, but yeah, you can change. Sometimes there's what we'll call a minimum earn provision in the policy that just says, hey, you got to wait 2 months or 3 months. But
Yeah.
overall, there's usually something to talk about.
And this may not be a fair question that's been asked, but I'm going to ask it anyway. If you're looking at range, let's say, you're a $5 million a year company. We'll just make it something reasonable here. $5 million a year company. You're making telephone calls. You're not a call center, but you're a company that's direct marketing to your current clients and potential future clients. And so you're interested in all the types of things we've been talking about, coverage for TCPA claims, privacy claims, D&O insurance, that type of thing. What kind of range are we talking about
I mean,
for this?
I've seen a complete proposal for a startup business who's doing 750,000 revenue,
Hmm.
for $1 million limits across the board with the side A, all that, might be 20 to 22, $23,000 premium, all in with all of those coverages we talked about. To describe a 5 or 7 or $10 million business, things start to get a little bit more dicey there, because if you've had activity, if it's clean, that will denote how
Hmm.
things work out. But I would say this: there are carriers that are willing to take minimum premium policies for 10, 12, $15,000 in the space for
Hmm.
TCP up to $1 million. I mean, it's not expensive.
Wow.
Um, D&O pricing is $5,000 to $7,000 depending upon the
Hmm.
situation. Sometimes you can get that for less. Side A policies are half that price. I mean, it is not expensive.
It's worth looking into. That's what I always tell everybody. And then
Yeah.
I give them
Yeah.
my phone
It's
number,
worth a
Otto, and tell them to
conversation.
give you a call. Yeah, and then to
Great
have that
conversation.
conversation. So I think that was the only question we had. Let me double check. But I'm sure if people have questions, Otto, your contact information is right here, and I'm sure you'd be happy with them reaching out. Feel free to reach out to me as well. And if I can't answer them, I'll forward you over to Otto to answer the questions. You were a baby in that picture, Otto.
Thank you, Michelle. Well, I kept the beer. Like my kids they're like, it's got to go, and I was like,
Okay.
it's going today after the webinar. So I want to go look all
Hey, thanks
official
so
today.
much for spending your afternoon with us. We really appreciate it.
Oh,
Great information, really great topic. And if I can ever return the favor, let me know.
thank you, Michelle. Thank you to all the folks at McMurray Schuster, top-notch firm, and really appreciate the relationship we have. And thank you so much for having me today. It's been a pleasure.
Our pleasure. Take care, Otto.
Have a good one.